Professor Mizanur, the sunlight is directly falling on your face, actually. I can't hear you. You've muted yourself. You need to unmute.
Yes, I have done it. So I think now it looks better, right?
Yeah, this is better actually. That time it was directly on your face.
Yeah, but still, I'll try to cover it with something.
Yeah. Okay.
It's just I'm sitting just in front of the window. That's why.
Yeah.
Okay, so what about the other speakers? I send them email or send them messages that they need to kind of.
So, I guess one of them is here. Gamis, Adam, to. Yeah,
okay,
one of them is here. Yeah.
Right. So, I mean, have you spoken to her?
Yeah. No, I haven't spoken to her actually. But she's mute. She needs to unmute. Yeah, she's unmuted now.
Okay, right. Now I can hear you. Yeah, I can
oh, great.
see
yeah, great.
you. Let me let me also
great.
yeah. Okay,
good.
So
it's working fine, right? Yeah. So sorry.
Yeah, it's fine. Yeah, on my end everything's fine. Yeah.
Okay. Thank you. So then we'll start like probably 5 to 5 like that, or probably 5.
Okay, sure.
Okay. See you there.
Yeah, see you. I'll just mute myself and turn off my camera for the moment.
Okay,
I'll be back.
Yeah, sure. Yeah. So I think I'll send them the other two speakers, but probably they will come online and they will check. So
okay.
So I mean, so I can sign out, right? And you can check.
Yeah. I'll check. I'll be there.
All right.
प्रोफेसर मिर्जा नहीं है
थे तो अभी
चले गए
ओके
अंशु मैम अंशु मैम
हाँ waiting for Dr. Uhma and Dr. Oeni, and then we can. I think Professor Mirjanur is not here.
no, so he left. He said that he'll come back at 5.
Okay. So
4:55.
panelists. Already 9 attendees there. Okay, fine. Let's.
That person is interested in the 3 years LLB course.
Who?
Sonali.
Okay. Take her number. Share Vinod sir's number.
She has not mentioned her number in the mail, so I did to Vinod. So he said he has already received her email today in the morning. She has mailed everybody. Deepu sir also mailed me saying please reply back to her, Anukya. So then I replied back. Then I got a reply that she's interested in 3 years course. I was like, okay.
We will. हाँ मम्मी ये रख दो ना बबड़ू मार्मरेड लाया तो बाहर का लाता है पता नहीं इम्पोर्टेड हाँ बंद कर दो चलो बाहर सामान ले आते हैं चल रहे हैं एक हम चीज स्टार्ट करके फिर चलेंगे Good evening, Professor. Anshu this side. Professor, I can't hear you. Hello? Professor Mijanor, I cannot hear you.
He needs to toggle between the audio, I guess.
I think he's unable to listen to us as well.
Yeah. Um,
Hello? Professor Mijanor, we can't hear you. Are you unable to hear us?
He's showing his screen right now. I don't know why. I was able to hear him when he joined earlier. Professor, you need to actually toggle between the audio.
Yeah. Professor,
Try
just
to-
see your. Yeah, I can hear you now. Yeah.
Oh, okay. Hello.
Yeah, I think it's working now.
Professor,
okay.
can you stop the screen sharing thing?
Yeah.
Stop the screen sharing.
Yeah.
Is it
Professor,
okay now?
that's perfect. Yeah,
Yeah.
I would want Doctor if to maybe switch on his camera and just check. Like.
Yeah. I've been sending him the webcam request. He needs to accept that.
Dr. Nee.
Yes, I'm trying to actually. It's telling me to open system preferences, but
Right.
I'm not sure I know how that works. But I'm just trying.
So there
This
is
is never happened.
the symbol, the camera symbol. I think you need to click on that.
Yeah, I think, Dr. Nee, we are sending you the camera request. If you accept it, I think the camera should work.
Yeah. When I click it, it says access my privacy settings or something. So
Yeah.
that's what
Do you have a MacBook by any chance?
Yes, I do.
Oh, yeah. So you have to go to the system preference and maybe allow the access for the mic and the camera. Then only this app will be able to.
Oh, okay. I'll just try that.
Yeah. So you need to go to the apps and then maybe settings, and then they ask you for access, and then you just have to allow the camera.
Oh, okay. Okay. So I am on privacy settings on the camera, and only two items are highlighted, the Skype and Zoom. So it appears the GoToWebinar isn't there. So,
I believe, because I have a MacBook as well, if you sign off and sign back in, because in my case, it asked when I was signing in whether I was going to enable the camera, and I said yes, and then I didn't have to go to the settings anymore. So that might be that might work for you as well.
Oh, okay. I'll do that again. Thank you.
So, Professor, so Anugya would be sending you the questions from the attendees on your email. Okay, and maybe at the we have this session for 1.5 hours. That was 5 to 6:30. So we can have the talk for an hour, and then we can have 30 minutes or so for the questions. So if you have some questions, you can ask the panelists. If not, then what attendees are asking, you can just maybe do kind of rebuttal and ask each of them.
Right, no problem.
Okay, thank you, Professor. I think Dr. Nee is here.
Yes, I'm back here.
Your camera.
So is it working me now?
I'm actually still not working actually.
Right.
The best, yeah, you may just you can go to the system preference and also allow this.
Yeah, the go to webinar is not actually coming up. That's the problem, and don't know, maybe there's some settings I had to do. The camera, yeah, the microphone is highlighted, the speech recognition is highlighted, but just the camera isn't. I don't know why.
That shouldn't have happened.
Oh.
So, did you go to the system preference and security and privacy?
Security and privacy, yeah.
Yeah, then privacy tab.
Yeah, it's just two items that are for me to highlight: Skype and Zoom.
Go to webinar is not there.
Webinar. Yeah, the go to webinar isn't there. Yeah.
Oh, okay.
From recording.
Maybe we'll have to start without.
Yeah, probably I'll just go via audio. I'm sorry.
Yeah. That's fine. So, Professor Mirjanur, should we start now?
Now let's start.
Yeah, so I think Dr. Nee's camera is not working, and I think he'll be only have to be available on the call, like on the audio. So maybe you can just tell the attendees that due to some technical issues, his picture cannot be available. So, and then we can have the. Okay. So, Professor, will you switch on your camera or should I wait? Yeah. Okay. So, Professor, I'm starting. Okay.
Right. Okay. Yeah, sure.
Yeah. 1, 2, 3. Just a second. Yes.
Is it ready?
Professor, you can start. Yeah.
Okay. So hello everyone. A very good afternoon to everyone of you. Thank you for joining us today for the webinar talk. We have two panelists who are outstanding scholars and speakers. Unfortunately, one of our panelists, Dr. Piotr Uhma, is unable to join us because of some urgent travel, and he's in the middle of his journey, so he won't be able to join us today. But we have other two panelists, and Dr. Adrian Turkelly, and from the University of Antwerp. She is going to talk about human rights and private actors, and her talk will look into a framework of human rights framework and conceptualizing human rights in a way that actually extends to private actors' human rights responsibility. And Dr. Wayne Abe is from the University of Cape Town, and he's a scholar in residence there in the Center for Comparative Law. And he will talk about, again, on the issues of corporate criminal liability in the context of the current pandemic. And his talk will mainly focus on how criminal liability can be extended to corporate actors, specifically by looking into the Malabo protocol. So I now request Dr. Turkelly to speak or to talk on his topic.
Thank you so much. I'm very, very honored, and I would like to thank Professor Mizanur Rahman and the Jindal Global Law School for inviting me to this very, very timely debate on human rights and human wrongs in the time of COVID-19. As I think it's been mentioned, I will focus more on the obligations of states to protect and fulfill human rights in the context of the pandemic, but also more generally, taking into account the very prominent role that private actors have played as business enterprises, but beyond. And my research focus itself relates more squarely to the involvement of private actors in the global economy. So I've done research specifically on children's rights in business and human rights more generally, but also on private financing for sustainable development. And I think the pandemic is an area where the right to health, but other human rights as well, coincide with the needs of sustainable development as they have been coined in the Sustainable Development Goals and beyond. So in this contribution, I will try to look into both within borders, but also beyond borders, how private actors have been involved in formulating, or necessitating formulations of responses that are different to what we're used to, because we are facing, and the countries that are, I think, everywhere impacted by this pandemic are facing difficulties in allocating not just financial resources, but human resources, goods to solving this global problem. And I will argue that we need a human rights system that allows us to interact and cooperate with private actors, but also in a way that allows states to regulate them efficiently and effectively in order to be able to respond to the needs of individuals and communities, and not just those actors themselves. And of course, private actors might link to COVID-19, so business enterprises might link to COVID-19 in very, very different ways. And I'm so glad that we will also hear about corporate sort of criminal responsibility issues, etc., in more detail, but I will look at a more normative perspective now. And I believe that there are two pertinent issues. One is within national borders, and the second one is a more systemic issue linked to how private actors shape our decisions, our responses to crisis situations, including the current pandemic. So we know, firstly, that the private actors I'm talking about, they interact with human beings, with individuals and communities directly especially when they're providing employment or when they are providing essential services. Sometimes those are privatized in many places in the world. Healthcare is privatized, and the right to health has to exist within a profit-making rationale. Especially we've seen, I think, in many countries, but also very particularly in the United States, where healthcare is a very much privatized provision, that businesses may get to determine who has access to vital treatment options, vital care, and who might be excluded on the basis of, and it's not just hospitals, but it's also insurance companies. So it's a national architecture of service providers that get to decide whether individual A has access to all these goods and services versus individual B. We've also seen that those companies that are producing essential equipment, such as ventilators, masks, protective gear, have tried to use arbitrage on international markets to obtain the best prices for their goods, and that we've seen mask prices hike up to, even 10 times what they were before the pandemic. And it has resulted, unfortunately, in a bidding war between different states on the use of ventilators, which also goes to show the weaknesses of the global cooperation system. So the duty to cooperate internationally, we see that state actors do not always cooperate with one another to make sure that every country at their peak of the pandemic has access to these resources, and that we can equitably share and share the duty of providing the right to health to every individual in the, at a global scale. We've also seen, very interestingly, even in Europe, in the most sort of neoliberal places, that states have sometimes confiscated or taken into custody stocks of private companies, of masks, of ventilators, of protective gear, saying we won't allow you to export them for the moment because we might need those goods within the country itself. So we will pay you the market price for it when we need it, but we won't allow you to sell it outside. And to me, this tells us the story of the state still being a very relevant actor in the realization of human rights. When there's a crisis situation, when the state reacts with all its force, it goes on to regulate private actors at a very macro political economic level, which would be unthinkable in what we used to call normal times, where you asked states to regulate, even at a very minimal level, companies, and the states were very reluctant because they said they didn't want to distort competition, or they didn't want to have an undue influence on the markets. So I think we need to maybe hold on to those lessons of the ability of states to regulate corporations more generally, even outside of a crisis situation. Maybe also in light of the climate change crisis, which is a longer term, slow onset crisis. So it's not overnight that we're going to be seeing the effects of climate change, but we know it's a crisis. And we know that states have an obligation to protect their citizens and more generally to cooperate internationally under human rights law. So we might hold on to those lessons when we need to regulate carbon emitting companies or technologies, to treat that as a crisis response in the sense that we've done so for the pandemic. So I think not everything is really dark. That yes, we've seen bidding wars of corporate actors that are really taking advantage of a situation that's putting pressure on public budgets, but we've also seen states respond to the pandemic in ways that might be inspiring more generally for human rights and business, particularly. So that's one part of the duty to regulate on the part of states parties. The other part, of course, is when states bail out or subsidize corporations within their borders. For instance, in the US or in, I think, different parts of the world, when they bailed out airlines that couldn't operate. We need to ask the question of whether our taxpayer money is going to be delivered to the managers of those companies as bonuses, as it happened in the 2008 crisis or when Enron failed in the US, or whether it will be used to make sure that those employees are not left unemployed from that industry. So within, I think, that framework of regulating private companies within the borders of states, we need to think about how we use our resources and how that regulation allows individuals and communities to benefit from the use of public resources. So I think those are the two big issues within the borders, and I don't want to keep this talk very long because I think it would be lovely to have a discussion as well. And the second issue, so I would like to go beyond borders to look at the systemic issues, and those relate to different parts of international law, the very specific regimes of international investment law and trade law regimes, and also taxation. Afronomics law had a very interesting online debate on taxation issues and previously on investment and trade issues. But we need to really take cognizance of the fact that a lot of corporate actors, transnational corporate actors, are very powerful, and states are sometimes at a disadvantage, especially developing states. And the pandemic has really sort of instilled a fear within some of the least powerful states, developing states, against investors who might take them to arbitration, to investor-state dispute settlement, because they can't deliver on their promises. We see that there's a debt crisis, and a lot of corporate entities that have actually loaned to states will be seeking their money back. And that's why a lot of people have asked for a moratorium on sovereign debt and even debt cancellation, because when you take a pandemic and the burden of that pandemic, and if you look at the European countries that are having problems and will go into the recession, you can imagine what it does to developing countries with a big population that need to then also pay their debts externally. So we need to reconceptualize how human rights law can interact with those regimes to make them more rights-friendly, and to take a rights-based approach to how corporate actors will be taxed, because they can very easily avoid taxation. You've seen the Panama Papers that companies have no qualms about moving their assets from one jurisdiction to the other, just to be able to avoid having to pay big amounts of corporate taxes, which means that those resources are being denied to public budgets in developing countries. So I think we need to recognize that the pandemic has put all these issues to the fore, and of course, in order to realize human rights and human needs, the COVID-19 crisis, I think, has shown us also the weaknesses of global coordination and cooperation at the state level, which is something we should be addressing. The recent withdrawal of the US from the World Health Organization, for instance, when this multilateral institution needs and relies on US support the most, because we're in the middle of a pandemic. It's a reminder to us, it's a very stark reminder that the rest of the globe maybe should be cooperating more efficiently to overcome those shortcomings. And that we need to look beyond the territorial considerations when we decide how to respond to these kinds of crises, so that we don't bid against each other for ventilators, or we don't make the most amount of profit for the company, but then have to pay it out of our own pockets, where we need to tax our citizens and pay those exorbitantly high prices to companies. and of course that these companies that are taking public money are keeping on their employees and paying them the wages that they're supposed to be paying them. So I think what we need, and the pandemic, what it reminds us is that we need a human rights framework that understands issues beyond borders and responds to them in light of global duties to cooperate between states, but also obligations directly incumbent upon private actors that are making money, that are using the global system in order to maximize their profits. We should also put in place systems to ensure that they are accountable and that they don't misuse these types of situations as opportunities for maximizing profits, that they are accountable to public entities when they take public resources in order to bail them out, etc. So my call would be to use the opportunity that the pandemic has afforded us in terms of reconceptualizing the normative bases of human rights law a little bit, to strengthen the regulatory role of the states, but also to recognize the weaknesses in coordinating, cooperating, and to overcome those systemic deficiencies in investment trade regimes that benefit investors, that benefit companies over individuals and communities. And I think that's basically the point I wanted to make and open up to debate. Thank you very much.
Right. Thank you. Very interesting to hear from you. So we will come back to you kind of with some questions, and then you can probably provide more analysis or kind of more explanation and more discussion. So thank you for your interesting talk. So now I request Dr. Nee to kind of start his talk. Okay, sorry. I think Dr. Nee, I think it's just to inform you all that Dr. Nee's camera is not working because of some technical fault. So he will be presenting or he'll be talking over the using the mic, not the video, not the camera.
Okay, can you hear me?
Yeah, we can hear you.
All right. Thank you very much, Professor Rahman, and thanks to the Jindal Global Law School for this opportunity given me. First of all, let me apologize, like Professor Rahman said, for some reasons, the video, I don't know why, the video decided not to cooperate at this point in time, but good enough that you can all hear me. So just to jump into the discussions that you've been having, or we are going to be having, and also to take to continue with the discussions from what Dr. Kelly just said about a human rights framework that understands issues across borders. And I'll be focusing on, with particular reference to Africa, in focusing on access to remedies for victims of corporate-related human rights violations. And this has always been a challenge, a problem over the years, but the pandemic has actually brought to fore the need to understand the peculiar realities that African countries are facing vis-a-vis multinational corporations and the local communities in terms of accessing remedies, both operational levels grievance mechanisms and non-state-based grievance mechanisms. And that's as regards to local context. Also at international context, I will also be looking at corporate criminal responsibility in terms of how do we ensure a tightened responsibility framework on the part of corporate entities, because there's been this argument that corporations are not objects of international law, but only states, and therefore you cannot sue them under international law. So these have created problems for victims of corporate-related human rights remedies, especially in Africa. And that's why we see a good number of cases, some of which I'll be speaking about, being heard in the home states of these corporate entities, rather than those states where these harms or violations actually do occur. So the problem, however, with this paradigm is the fact that the Malabo Protocol, which actually looks to expanding the jurisdiction of the first regional criminal court in Africa, has not been ratified. So I'm looking at the reasons why this has not been ratified, and why, if this is ratified, it would create an enforcement mechanisms for victims in Africa. So my question basically is looks at corporate criminal responsibility for human rights violations in the extractive resource industry in Africa. And basically I'll be looking at different countries have different extractive resource industries. Like in South Africa, we know it's mining. In Nigeria, it's oil and gas. And in other parts of Kenya, for example, is wind, renewables and non-renewables, and in other parts of Africa. So my question looks at corporate criminal responsibility for human rights violations in Africa's extractive resource industries, and whether these can be addressed through an expanded jurisdiction of the African Court of Justice and Human Rights. And my focus is born out of the idea that when corporations face no consequence for their criminal behavior, we kind of minimize their lawlessness and increase the kind of cynicism about the outsized influence of corporations. As you all know, the pandemic has actually brought out the different disparities between access to even health. And we know that those who are most impacted, that we all hear about in the United States, that those who are most impacted are African Americans and people of color. In Africa, it's also the same thing. In South Africa, for example, the majority of people impacted by this pandemic are those with high degrees of comorbidities, and these are blacks. It has to do with access to remedies and style of living. Despite this, during this pandemic, multinational mining companies have continued to operate, and the vast majority of people who work in these mining companies are blacks. So in as much as they do not have access to the best healthcare, economic, social, and cultural rights guarantees, access to health, they also do not have access to effective remedies when these kinds of harms occur. So, and this creates a dilemma. So some of them have to struggle with literally putting bread on the table, and at the same time actually enforcing or ensuring that companies actually do that which is right and guaranteeing the best living they can actually get. So my assertion is based on the fact that because we deem corporate entities as legal fictions, corporations exploit this benefit and they violate the public trust by engaging in illegal conduct. Now, because there is this pandemic, the monitoring mechanism is also not there. So, I mean, everybody is talking about hunker down shelter in place. So we don't have the capability right now to actually ensure that companies, especially where you have deep seabed mining, actually comply with some of the safety mechanisms various states have actually suggested. So going back to the Malabo Protocol, the creativity of the African Union to amend the protocol and the statute of the African Court of Justice and Human Rights, which matched the African Court of Human and People's Rights with the African Court of Justice, has been mixed with mixed feelings. So basically what this protocol on amendments to the protocol on the statute of the African Court of Justice and Human Rights, actually otherwise known as Malabo Protocol, actually says is it duly expands the jurisdiction of the African Court of Justice and Human Rights, and consequently establishes the first regional criminal court in the world to adjudicate cases of corporate criminal responsibility and illicit exploitation of natural resources. So this is very important considering the African scenario. No international criminal court actually adjudicates cases of illicit exploitation of natural resources, and this is a very important problem or challenge for Africa. So, I mean, there has been some arguments whether to incorporate so many of such crimes, which are not provided under the ICC. But apart from the crimes of genocide, crimes against humanity, war crimes and aggression, which is under the International Criminal Court, the African Court jurisdiction will now be expanded to provide for a good number of crimes. Most important for my discussion is the illicit exploitation of natural resources. That the African continent is taking this pivotal step towards corporate criminal liability is not surprising, considering the fact that achieving extractive resource management has been a monumental challenge of African countries. Pandemic or no pandemic, There's the extraction of natural resources still continues, but the challenge of actually leveraging this for sustainable development still remains. And looking at the case studies which I highlighted, in South Africa, we have the case of the Maracana incident 2 years ago, where the Lonmin, which is an Anglo-Dutch company, 34 miners were actually killed when they were just asking for improved living conditions and remonstrating. And in 2012, what happened? The state apparatus, through the assistance of this company, actually killed about 34 miners. In Kenya, for example, there is the Lake Turkana Wind Project, which indeed is going to create a kind of foreign direct investment for the people and the government of Kenya. But the question of the environmental impact of this project, land displacement, even at this period of the pandemic, in terms of environmental degradation, in terms of the indigenous communities impacted by this project. And the most the important case out of all this scenario is the fact that local community have not been able to obtain the necessary justice even at the local courts. And that is why some of these cases actually move towards the home state of the multinational companies. And two cases actually are very important for this. Two cases are very important for this discourse. One is an Eritrean case, which was just recently decided in Canada, where I think Nefson Resources Limited versus Araya, where two refugees from Eritrea and Eastern Africa alleged that they were forced to work at a gold, copper, and zinc mine owned and operated by a mining company which was operated by a Canadian company. Although the court did not decide whether Nefson was responsible for violating this workers' rights, it said that the workers' lawsuit could go forward, and said that the trial judge will have to decide whether Nefson breached customary international law, and if it did, how it should be held responsible. Another case is the Vedanta Lungwe case, which is a Zambian case, which was decided in the UK courts, where the Zambian farmers alleged that their health and livelihoods were harmed by water pollution caused by copper plants owned and operated by the subsidiary in Zambia. The UK Supreme Court found that the Zambian villagers could proceed with their claim in England, notwithstanding that Zambia was the proper place for the claim to be tried. Case, of course, which has received a lot of literary reviews, the US case of Kyobel versus Royal Dutch Petroleum, held in the United States, which unfortunately failed. Now, the reason for this highlighting these cases is the fact that justice delayed is justice denied, as we all know. And while it is important to find justice at any particular forum, my own argument is that Africa remains the proper forum to actually obtain remedies or justice for victims of corporate-related human rights violations. But how can Africa be a proper forum when, in terms of the international space, the Malabo Protocol has not been ratified, and in terms of even at the local space, especially during this period of pandemic, it's very difficult to obtain justice concerning a significant number of issues relating to corruption, inefficiency enforcement, and related issues. But in just summing it up, I believe that the collective sense that justice was served in communities where companies break the law is an essential ingredient for the affected communities to heal and face the future more confident, excuse me, that corporate lawlessness would not be tolerated. And when corporations engage in criminal activity, their conduct must be addressed by the criminal justice system, which is closer to the people. It is unbelievable. I mean, it is totally inconceivable for us to think that victims of human rights violations at this point in time would prefer to go to the home states of multinational companies, which are predominantly in developed countries at this time of the pandemic, when even most international restrictions are in place. But it could have been a different case. If, for example, the regional criminal court, whether it's in Arusha or in Ethiopia, it's more closer to the people, the local justice will be served, and justice is brought closer to the people. And that is if the protocol is ratified. So the protocol allows us to think more creatively about what the corporate justice looks like. It looks at the types of claims, actors, appropriate levels of adjudication, and it offers the continent an important vision of regional criminal justice. So it's more like adapting criminal accountability to African realities, and it also it could potentially address the charges of a foreign institution opposing its will. After all, the debate about the argument against the ICC is the fact that it's not tolerant of African leadership, African political leaders, and there's been a wave of protest against the ICC, with some countries actually pulling out of the ICC. And of course, the question of whether the ICC is serving its purpose, is it truly the world's court, funding is tied to EU, and the political and economic blackmail makes it more realistic for African leaders to actually key into the Malabo protocol. And I also understand the fact that there are challenges, of course, to the protocol in terms of one of the provisions, however, says that there won't be any jurisdiction over serving heads of states or government, and as a result of this, the European Union is threatening not to support. But in all, I'm not oblivious of those arguments. I'm not oblivious of those challenges. But my argument is basically due to the fact that due to the existence of geographic, historical, cultural bonds among states, especially in African states, the regional criminal court decisions would be widely accepted and met with less resistance than ICC. So that even where victims of corporate-related human rights violations at the local level find it difficult to actually obtain justice against the monstrous power, size, influence of these multinational companies, they can easily approach the regional criminal court, which of course goes beyond the decision, goes beyond the authority of one state, and obtain justice rather than traveling, taking evidence, taking victims to home states of these multinational companies, which will be extremely very difficult, especially during this pandemic. And again, the court is linked to regional political bodies of the African Union, which makes the judgment enforceable. In the case of Nigeria, for example, where the courts give judgments against multinational companies, but the multinational companies circumvent the judgments of the court and therefore approaches politicians or political leaders or the state to circumvent the enforcement of the court's judgment. This will not be the case where we have the regional criminal court, where it's linked to regional political bodies of the African Union, which may facilitate stricter oversight, and where even regional blocs will intervene. And there could be suspension of members that refuses to comply or enforce the court's judgment. Again, the proximity of this international court or regional court to those affected could legitimize the process and the court's credibility, hasten search for justice, and thereby influence the court's effectiveness. I must quickly have here that one of the reasons, of course, why the judgments have been justice has been difficult for victims is the fact that most multinational companies that are operating in Africa have this orientation or perception that because of huge level bureaucratic bottlenecks or corruption, it's very difficult to obtain justice for them in African courts, wherever that orientation is coming from. So, but even if giving them the benefit of the doubt, where you have a regional criminal court or an international court, for example, this would, of course, create a kind of legitimacy and court credibility, and therefore influence the court's effectiveness. However, in looking at this, we also have to looking at the workability or the functioning of this court. We have to look at accountability and transparency, which must be integrated into the financial expenditure and budgetary allocation to ensure independence, at least to create a corruption-proof or corruption-free international criminal court. So hopefully the court, especially in this time, the court to be an avenue for local communities who are impacted by these corporate activities to be able to seek justice outside the confines of their state, where it has proven difficult, and where justice can be obtained at the local level. It's highly encouraged, But I'm saying even at international level, at the sub-regional level, at the regional criminal court will create an enforcement mechanism and a route towards ensuring access to justice for victims of corporate-related human rights violations, especially in this time of the pandemic. I open the floor for any questions or discussions. Thank you.
Thank you, Nee, for an interesting talk. So now the panelists are kind of willing to receive any questions, any comments, and obviously, depending on the questions, the panelists will obviously reflect and provide more analysis and discussion. So just to kind of, I have a few questions, so just we can kind of start discussing. So Dr. Tukeli, you have pointed out that you want to kind of reconceptualize the human rights framework. Now, looking into the kind of the UN initiative on business and human rights. So the UN has taken a number of initiatives, and issued a number of declarations as well. So, do you think that those the human rights framework proposed at the UN level, how far those framework or those initiatives, how far they are effective?
Yeah, thank you so much. And I think it's an important point to recognize that a lot has happened over the last 30 years. And I think some of it has, so it's been back and forth. I think there's been some proposals much earlier that went far beyond what Professor John Ruggie proposed in the UN Guiding Principles, or the framework and the guiding principles that are accompanying it. That didn't engender consensus. So we were kind of taking a step back and saying, yes, states have the obligation to protect human rights. They also, of course, we recognize they have their obligations to respect and fulfill. So we say states have all the facets of human rights obligations. Of course, the companies, the businesses were given a responsibility, which was to say it's not a legal obligation, but to say it's a moral, political obligation, well, or duty, let's say. It's not enforceable in a way under the law, but it's still important because they have a societal relevance, and so they have to abide by certain norms, and that's a respect duty. So I think it doesn't, and then of course there have been national action plans. A lot of businesses have also kind of come on board, and so every year there's a Business and Human Rights Forum at the UN. There's now an academic journal that looks at the different aspects of how these things play out. So I think a lot has happened, and I don't discount the value of the progress that has happened. There's, of course, as I think a lot of our listeners will also know, there's at the UN a push to have a binding treaty on business and human rights, which started out as a treaty to impose direct obligations on businesses, but then it seemed quickly that under public international law, it's a state-based system, so it's really hard to bind states or companies internationally without, directly without them becoming parties to this treaty, which would not happen. So now the move has gone, and I think I would support this, that home state regulation should be mandatory when the companies go into developing countries mostly and exploit resources, start exploiting people and communities and grabbing land. But I think it doesn't go far enough. I still think that there should be legal obligations incumbent, not just on business enterprises, but also, multilateral development banks like the World Bank, when they finance these kinds of projects in different parts of the world. But one thing I think that has come out of the UN guiding principles that's really, really valuable, and I think today that right to remedy resonated a lot just previously, is really the right to an effective remedy that individuals and communities have. And I think the UN guiding principles really sort of focused on that, and I think that's a very welcome focus. I think that wasn't there initially when the normative thinking happened, but I think that's the one practical aspect that we can all agree on is really fundamental for rights holders. And so I think in that respect, a lot more has been done and a lot more needs to be done, but at least at the company level even, there's recognition that yes, even if courts do not adjudicate this, they should be providing rights holders with some form of mechanism. And of course, I think we need to rethink how those mechanisms work, because most of the time they're not as independent as they should be. They're not as objective as they should be. But I think that's the one thing that has come out of this process that is really to be applauded, that focus on the right to remedy for those people who have been affected by these projects or these supply chain issues. And I think there needs to be sometimes more formalization, but even informal processes are sometimes better than no process at all. And so I think that's the one area where law is sort of judicial and non-judicial mechanisms have been combined in a more effective way. I still think the normative framework is lacking a lot. But I think that's the area where the most progress has been made to my mind. And it's imperfect, but it's still something.
So what do you think? I mean, the international level or the UN level, what's the main difficulties, or you might say, what are the hindrances or challenging aspects of holding corporate entities liable? I mean, why it is so difficult at the international level to kind of frame a normative framework or a treaty, as you are saying, a binding treaty? Why it is so difficult to achieve that kind of legal normative framework that will kind of hold the multinational corporations liable? What are the problems at the international level?
I would say there are several, right? So I would say first is an issue of structural power imbalances. And multinational corporations have enjoyed a lot of power. They've always done so. I think in the 1970s, there was when the idea of the new international economic order came about. And when the ILO, the International Labour Organization, drafted its tripartite declaration, the OECD started drafting its guidelines for multinational corporations. The focus was more on developing states being very powerless or rendered powerless by how much those corporations were supported by developed countries, some of which were former colonial powers. So I think if you look at those trade and investment regimes, for instance, the EU one in relation to former colonies, you see that they've always been about opening up markets to European companies. So they've always negotiated, so the European countries have always backed their companies in negotiating preferential access, better conditions for them to do business, which I think continues to this day. When you look at the treaty mechanism, when the first resolution came about, it was supported by Ecuador. So it was tabled by Ecuador and South Africa, supported by a lot of developing countries, but opposed by essentially the big wealthy countries of the world that wanted to keep on working on voluntary guidelines. And now we have a two-track process that is going in parallel. So both is happening, but a lot of I think states that are wealthier have a lot to lose from that power imbalance being settled in favor of those that have been marginalized, that have been disenfranchised. So I think one thing that is not in favor of developing countries and their peoples is the fact that this is such a historically ingrained process, and it's reckoning is difficult. And we see, you know, with the Black Lives Matter movement, with the people of color suffering, as I think it's been mentioned, from the COVID crisis disproportionately in even the wealthier countries, it shows that there are a lot of ingrained structures where multilateral processes try to make leeway. And I think civil society in a lot of wealthy countries also recognize that there needs to be change. But it's not across the board. And I think a lot of companies still have a lot of domestic power within developing countries, but also wealthier countries. And it's really hard to put in place these mechanisms that essentially means more taxes, sort of, you know, criminal responsibility possibly, instead of doing whatever you want to increase your profits. And accountability is a fight. And so I think people will fight back against being accountable, and that's something we need to also take on board, and to see how much you know, change can happen within those formalized processes, how much change has to happen at the grassroots. I think we need to do both.
Yeah. So I mean, looking into the current pandemic situation, I mean, and there's a race to kind of find a cure and the vaccine. What we see right now is that, I mean, the number of companies, multinational corporate companies, are actually working towards a vaccine, and from a right to health point of view, these corporations obviously want to kind of market their vaccines, and specifically when it comes to accessing those new vaccines for the COVID-19 virus. You see that the wealthiest countries are actually kind of trying to procure, or kind of trying to kind of get as much as access of those vaccines. What about the right to health of people living in developing countries, and how do you reconcile this tension between the wealthiest countries, that, I mean, kind of their corporations and their investment on finding a cure, or finding a vaccine for the COVID-19 virus, and people living in developing countries? What about their, so how, I mean, what do you think about how to reconcile this, the right to health issues of people living in developing countries and those who are living in the highly developed countries, how to reconcile, and what kind of responsibilities can be imposed from a human rights perspective on pharmaceutical companies who are actually kind of working towards bringing a vaccine in the market? What do you think about that? I mean, kind of reconciling the rights. So don't you think that there is a tension within the human rights norms, that the right to health, for example, people living in developed countries, and the violation of the right to health of people, the erstwhile third world or developing countries?
I mean, definitely there is a tension, and there is also within the institutionalized legal framework, within the conventions, the covenants, there is a tension because, of course, the wealthier states, the developed states, have a duty to cooperate, but it's but then it's always that territorial aspect that comes first. So it's always going to be your citizens or your population that will get the first access. And unfortunately, we don't, the international legal regimes are so fragmented that the human rights regime is almost completely separate from the investment regimes, and the global injustices or the global power imbalances that I mentioned, the fact that the wealthier countries are wealthier has a history behind it, right? It's not by coincidence or by chance that these countries have developed the way that they have. The raw materials they've procured from elsewhere in the world, and so their development trajectory has been linked to taking from other parts of the world, essentially. And now, of course, they have the public resources. They have better, sort of more efficiently run taxation systems, although that might benefit some parts of the population more so than others, and they might, not tax corporations the way possibly we would like them to. But there's a systemic issue, and that creates a huge tension for people living in developing countries and their rights. Because, as you mentioned, of course, the access to that vaccine will be prioritized for if the United States or European countries are putting public money into a vaccine, they're of course going to want to roll it out in their country first, and they're going to prioritize that. And that's also, from a political legitimacy point of view, normal, because they have the electorate and they're accountable to their electorate, and those are the taxpayers that put the money in. But if you think of it more systemically, I still think that we should be relying more on this idea of global obligations for human rights, that where we can mobilize states, but also tell pharmaceutical companies that, of course, a lot of the raw materials that they've used for ages in different, not just vaccines, but in different types of drugs where they've made their money, have come from the developing world, have been indigenous plants. That's why we need the Nagoya Protocol, and that's why we need to protect the intellectual property originating from developing countries, because it's been used without protection for so long. And I think we will have to have states come in and intervene and to say, okay, you know what, let's remember the case of antiretroviral drugs when we had the AIDS pandemic. And we have to make this affordable. We have to make this affordable to people who live in developing countries, who have just as much a right to their health, to public health, as people living in developed countries. But I think it's going to be an uphill battle that we need to find allies within developed countries and constantly communicate this need to have those obligations in place, have those duties in place. And of course, there are new initiatives that are, which is something I work on also, multi-stakeholder partnerships. But so those global alliances have been putting money in, different trusts, philanthropic organizations have been putting money into the COVID-19 pandemic vaccine response. And I guess because they're also funded by public bodies, and pledges from countries, but also pledges from different international organizations, they will have to be the ones to probably intermediate those tensions. But it's not going to be easy, and I see how there will be a first world and the rest of the world in this type of situation.
Thank you. So we have received a number of questions from the participants. So these questions are for both of the panelists. So one participant has asked a question which says that, can we consider the DNA testing in paternity cases, or when there's the issue of paternity challenges? In those cases, can we actually look into this DNA testing to find the paternity of a child as a kind of human right of women? So one participant is want to know more about that aspect of the human rights of women. What kind of human rights violations are there in case of paternity testing, DNA testing, to decide the motherhood or the parenthood, the parents of the child? Can you please, both of you, a bit reflect on that aspect?
Yeah, sure. You're talking about the impact, how it affects children, if I understand the
Yeah,
question.
the
Oh,
children's
okay.
right, or from a women's right
Oh,
perspective.
okay. Yeah, I think it's a very important aspect, and currently now, one of the main issues about the UN guiding principles on business and human rights, it's about, and I think the UN working group is actually working aggressively on these, is on the gendered impact of businesses, especially in Africa, and most of the cases which I alluded to before. There's actually an ongoing case in the United States which was brought out by um, uh, some claimants who were used as child farmers, the cocoa plantation in Cote d'Ivoire, Nestle and Doe case. And the argument was that, and the company was actually had the nerve to actually argue that it didn't contract directly with those farmers, but it contracted with local farmers who in turn used those children on the farm. So the issue of using child slavery, it's a very paramount thing in Africa. And of course, women, especially where the society is still patriarchal in nature. So women are actually more impacted by, in terms of fetching firewood, in terms of cooking, domestic activities for the people who work in mines and all those and those kinds of work. So the impact of and there's no protection. Okay, so there's no protection, no economic, social, or cultural rights afforded to these people in terms of these instruments are very important, even though they are normative. And if I can quickly go back to the first question which you raised before about the implementation of the UN guiding principles, um, though they are normative, but the fact that, and that's why I think Rogi said that the expectation is that over a good number of years, these will become a kind of culture for companies to utilize in terms of using them. And if the fact that these guiding principles have actually existed for 9 years, I think it's an indication that it bodes well for the businesses working in Africa. So even though companies do not sign to most international covenants, the states, right? But the mere fact that they are not parties to there's an international conventions on elimination of discrimination against women, international conventions on child slavery, and even though states, well, the fact that states are parties, it beholds states, and this is why I keep coming down to the domestic level about states' usefulness in crafting policies, legislations, and even if they're normative frameworks about these issues in terms of child slavery, in terms of abuse of women, in terms of other areas where their activities might be impacted. So I believe the onus is more on the states to actually enforce their laws. But in a situation whereby victims do not have recourse to justice at the local level, where do they turn to? And you'd see that, especially with the conversation we've been having, you see that most of these victims actually turn to home states, and most of the laws and most of the either normative framework or laws that have actually been crafted to guide against some of these abuses, either gendered impacts or child slavery, have actually been coming from developed nations, from the home state of the multinational companies. We have the French duty of due diligence, we have the OECD guidelines on multinational companies, where most African states are not parties. So the precarious situation of most developing countries, so to speak, it's something that I think becomes even more important, especially at this time, and looking at how child slavery and gendered impact of businesses on women can be effectively looked into.
Thank you, Dr. Nee. So there's another question. One participant is asking that the biggest challenge in developing countries is that a large number of population are illiterate, and most of them don't even know about what human rights they have. What are their rights? So in this context or in this situation, how can you provide remedies to people who are illiterate, who don't even know that their human rights have been violated because of the pandemic. During the pandemic, I mean, almost all governments throughout the world have taken drastic measures and restricting people from doing so many things. And when you look into the population in developing countries who are mostly illiterate, large number of population. So how do you provide remedies to those people who are not even aware of their human rights?
So one of the issues is, I mean, information. In some of the research I have been conducting on the UN Guiding Principles on Business and Human Rights, especially in South Africa, for example, it may interest you to know that the vast majority of people actually do not know that such a document exists. And for you to think about the fact that South Africa and Ecuador were the two countries that actually initiated the process, passed a resolution for a binding treaty on business and human rights is even more telling. Well, one of I completely agree. The problem, especially with us to do with immigrants or documented immigrants or refugees, as we call them, it's a challenging issue. And when you look at the amount of trade within Africa, it's recorded that the fastest growth actually it's informal cross-border trading. And because it's formal, of course, there is no statistics to show the number of people crossing the border and the amount of trade that comes in between. But we all know that there's a huge amount of trade that traverses within African borders. So as a result of this, it's not very easy to quantify the amount. Definitely, I'll be so surprised to hear that there aren't any human rights violations. There are human rights violations, but the question is, how do we ensure that these violations are reported? And this is where the work of non-governmental organizations actually come in place. And we have a good number of them actually working in South Africa in terms of creating awareness, protecting refugees, documented immigrants, and a good number of cases actually which have been filed, especially against the state apparatus like the police, and some of the cases have been won. Some of them have been kind of political in nature. So some of them have actually been done at pseudo-judicial, quasi-judicial level in terms of appealing to the state to protect them. States are actually obliged to protect the rights of immigrants. So the mere fact that you're an undocumented immigrant does not mean that you don't have recourse to the protection of the law. But I understand that because some of these claimants might be undocumented, and we have a huge significant amount of them working in the mining industry, and that is why it's a challenge to actually bring justice for these people. One of what they're afraid that if they come out to talk, they might be deported or they might be harassed. But I believe with the continued increase in terms of awareness for by the non-governmental organizations and by also some states, especially in South Africa, is actually doing well in terms of refugee protection, so it has its own challenges. I think it's over time, the issues will be resolved. But the case is how people should be able to trust a particular system or a particular organization to be able to report the activities that they see. And when those activities are reported, it's the expectation that NGOs will treat those cases, those violations respectfully, and treat human beings with dignity. Either you're an undocumented immigrant, you're a refugee, you are with a right to human dignity and all the protections, fundamental human rights protection. So the mere fact that they're undocumented immigrants, I don't think, or refugees, I don't think erases the fact that they can be protected.
So one of the issues we faced in India is that once the government imposed a lockdown, and in India, a large number of people, migrate from one place to another, from one state to another state for the purpose of work. And when the government of India imposed a lockdown, then these migrant workers they had a very hard time because because of the lockdown they already lost their jobs, they already lost their work, and they had to return to their homes in other states, and they had a very hard time to travel. Even there were, probably you have read on the news that even some migrant workers, they had to kind of walk, like like thousands of kilometers to reach their home, right? So so imposing a lockdown obviously is a restriction on the movement of people, right? So what do you think about from that perspective? When those migrant workers, they are mostly illiterate, but obviously they have no knowledge that their human rights have been violated. So how do you kind of reconcile, I mean, in terms of protecting the human rights, in terms of providing remedies to those people who doesn't even know that their human rights have been violated?
Yeah, so yeah, so I believe, I mean, in like the case in Nigeria, for example, and which I think is also what you had in India, there was no difference actually between refugees and even citizens when it had to do with lockdown. Everybody was impacted equally, and it could have worked in developed nations, but where you have an increasing number of unemployed citizens, and then you impose a lockdown, people will have to, and that's why it didn't work effectively. Especially in the lockdowns didn't work effectively. Most people actually broke the lockdown rules and restrictive rules. But in terms of, so whether it's immigrants or non-immigrants, or whether it's citizens or non-immigrants, I believe that the first of all, the question is understanding that the fact that you're a human being, you have a right to human dignity, you have a right to recourse, you have a right to access justice, even if you are in a country that is not, I mean, foundationally yours. And under the various international covenants on economic, social, and cultural rights, under the Bill of Rights, basically, and the Universal Declaration of Human Rights, you are guaranteed some of these fundamental rights and liberties. So, and you are protected, even as a refugee, to any of those kind of rights you may want to seek recourse to, even under the lockdown. If you have a total lockdown, yeah, it could be problematic in the sense that people, by nature, we all know that refugees are fleeing conflicts and persecution, and more or less, this pandemic is a persecution on its own, even though it wasn't caused by any nation or individual or entity. So that actually behooves the states to protect even more for these precarious set of people, or no, not precarious, trying to actually look for an adjective, these people who otherwise would not have been protected, because they're in a very unique and vulnerable, yeah, that's what I'm actually looking for, there's vulnerable sets of human beings. The states, it behooves the states to guarantee them adequate access to water, electricity, life, food, and everything. And I understand, and that is why, in terms of economic, social, and cultural rights, in most countries in Africa, first of all, it's not guaranteed. And even where it is guaranteed, the state actually struggles within scarce resources, provide scarce resources in terms of juxtaposing which one should we provide and which one should we not provide. So I discovered it's actually very challenging in developing countries. But and the pandemic, of course, does not really help matters. But I believe that as a refugee, you're actually entitled to this protection, even as citizens of the country where you are.
Right. Okay, so there's another very interesting question that both the panelists. One participant is asking, what should be the contribution of the community in terms of protecting human rights, or in terms of providing remedies to those whose human rights have been violated?
Ms. Anur, did I hear it right? Community, you meant?
Yes, the contribution of the community in terms of protecting human rights, or in terms of providing remedies to those whose human rights have been violated.
I think it's a really interesting also follow up to our discussion just now. I think even though we might have people who haven't gone through formal education, who are considered illiterate, and who probably don't know the language of human rights and the legal obligations, that this is in the law somewhere in an obscure convention internationally. We've always had, I think, grassroots resistance, and I think that's really, really valuable. That's the community contribution, I think, that we should be sort of privileging, because even though you might not have the legal language of human rights, when you go to communities who are affected by any human rights violation, whether it's a corporate one or from the emanating from the state, you will have it voiced as something else, as justice, as equity. You will say we don't deserve this. You will hear people at the grassroots, at the community level saying we don't deserve this, or why do we not have the same conditions of living that those people have, because we're hardworking, we didn't do anything wrong, and so you will have a different articulation. You might not have the legal formally educated language, but you will always have grassroots resistance. And I think communities have been really, really at the forefront of these justice sort of crusades in a way, against companies particular. I mean, when you think of the Bhopal case, right? Yes, you did have people like Upendra Bakshi, who was articulating those grassroots resistance claims into the language of the law, but you still had people there who were there, who were affected, who felt what happened to them, and who were living with the consequences. So I think that, of course, those people who have the platform should be cooperating with the grassroots movements and the communities to give a platform to their voices, to raise their voices. But I think there's still, even if those people have been disenfranchised, they know at the core level that they are living through violations, and they do demand maybe better treatment. And so I think their role is really crucial in that we don't have any sort of real human rights without the communities and without the people, because otherwise, it's just abstract, obscure ideas. And the lived experience is what makes it valuable, and the lived experience of violations is what makes us attuned to, okay, this can happen to some other person, so we need to regulate at a legal level. So I think the role of communities and people is really at the heart of it. And sometimes the law doesn't reflect the justice that is sought. So that's when we need to change the law. It's not that we have the law and we had apartheid, we had racial segregation, and that was the law. And saying that this shouldn't be there was seen as an act of resistance, but it wasn't always seen as legal resistance. And now the law reflects the really moral considerations we are seeking. So I think that's fundamental.
Thank you. The last question we have, and because we're close to time, this question I think probably me would be the right person to answer. One participant is saying that African governments are inviting or welcoming investment from multinational corporations. And on the other hand, when you're talking about corporate criminal liability, or the criminal liability of corporations, and you are referring to the Malabo Protocol, which gives a kind of jurisdiction to the African Human Rights Court to adjudicate criminal liabilities of corporations, then how do you reconcile? And on the one hand, governments are inviting the African governments, especially specifically in the health sector, where the most needed investment is kind of required, and African governments are inviting those the large multinational corporations to invest in the health sector in Africa. But on the other hand, you are kind of penalizing or kind of labeling criminal liabilities against the corporations. So how do you reconcile? How should these two issues, two contentious issues, should be reconciled? I mean, looking into the language of human rights.
Yeah, thank you very much. That's a very important question. But before I answer this question, if I can just quickly refer to the earlier question which you asked concerning contribution of the communities in terms of protecting human rights. I think we have to actually understand the role between businesses and local communities, the kind of relationship that exists for we to be able to identify what is the local community doing. Oftentimes we hear, especially in developing countries in Africa and Latin America, we hear local communities actually taking up arms against the businesses. So the question is, how do we leverage and strengthen social license to operate to ensure business sustainability? So the idea about business and human rights, corporate social responsibility, is for businesses to do much more beyond what the law says. And that's where the social license to operate comes into play. You discover that most of the times, most of these multinational companies, they actually have the legal license to operate, which is given by the state, but actually lack the social license to operate. And the social license to operate can actually be given by the local communities. So the question is, how do you know how you get it right, but you know when you get it wrong? So the issue is, how do you incorporate in terms of procurement, in terms of employment, in terms of incorporate security? How do you bring in the local communities? You cannot say because you have the legal license, you therefore go to the local communities and engage in environmental degradation, engage in land expropriation, especially where you have indigenous communities that have used their land for spiritual activities and everything. But like one of the cases I was involved in research in South Africa, you discovered that when there was a particular company that incorporated these local communities in terms of its employment, in terms of procurement, the turnaround time was actually increased significantly for the company. And you know that when local communities, first of all, the relationship, the shared contract is between the local communities and the state. So when the local communities cannot actually obtain justice or get justice from the municipalities, they turn to the people they see every day, which is the company. And therefore the companies are saying, well, we pay taxes, we do this, why is this all our problem? So I think we have to just understand the relationship first and foremost between the businesses and the local communities before we can actually appreciate the contribution of the community in terms of protecting human rights. But I strongly believe, and I agree, I strongly believe that the local communities are actually for protecting human rights, considering their context. Now, in terms of the question which you asked concerning African governments, I'm inviting foreign investments, and then now we are saying liability for corporate criminal responsibility. It's a very important topic. Africa needs investment. I'm for investment. Okay. So, but the question is, how do you leverage these investments in terms of sustainability? Okay, so we need investment, but I believe we have to do investment in a sustainable way that we create jobs, create clean energy, respect the environment, and provide jobs for the local communities. The local communities are not saying we don't need jobs. They are not saying we don't need better life. What they're just saying is that just make sure that our standard of living is improved. But oftentimes you see a good number of investors that come to Africa have, if not all of the things that they cannot do in their home states, they're actually doing that. I refer to the case of Nestle earlier on that was involved in child slavery in the farms of Cote d'Ivoire. If Nestle is a Swiss company, Nestle cannot take Swiss children into the farms in Switzerland to engage in extracting cocoa, assuming Switzerland has cocoa. And we have a good number of companies, for example, in Nigeria, we have the Ogoni incidents in the Niger Delta, oil and gas, where there has been gas flaring. In a particular community in Nigeria, for example, in Akwa Ibom, when you look at the sky, instead of seeing a blue sky, what you see is a dark sky because of over the years of gas flaring. And the impact of this is not a 5-year thing, it's not a 10-year thing, it's a generational impact where you have later in life, you have children giving back to children with deformities and everything. Now, Shell, which operates the Niger Delta, is an Anglo-Dutch company. Shell has stopped flaring gas in the UK and Netherlands over decades ago. So how is it that they are still flaring gas in Nigeria where they operate? So you see that there's a disparity between a kind of structural imbalance between where they're coming from and where they are. And they say that most of them say that, well, we come to these countries, we try to enforce the law, but we even discover that even the people there don't even care about the law. If they don't care about the law, you should be a corporate citizen, a good corporate citizen. So that's why, I mean, we cannot say because we need investment and we therefore turn our blind eyes to reparations or criminal justice or liability. If companies do that, which is right, if they actually invest responsibly, I don't think there will even be the need to actually talk about corporate criminal responsibility. And we look at most of the international financial corporations, the World Bank, the IMF, they have actually come up with significant documents. You might call them normative, but they've come with sustainability framework documents, whereby if international financial institutions are going into some of these countries to invest, they must carry out environmental impact assessment. They must ensure that before they invest in any of these projects, those projects actually are in line with human rights, environmental rights, and other economic and social rights. Because they now realize 10 or 20 decades ago, the World Bank wasn't talking about the environmental impact assessment, but today they are talking about that. So I believe that it is important that in as much as we need foreign direct investment, we need it, foreign direct investment in Africa, but we should also ensure that these foreign investments actually impact the people positively. So I think we should begin to think about going into a knowledge-based system where people realize that it's not just about investment, it's also about corporate responsibility.
Thank you, Neil. So we are already over time. We are already crossed the time limit. So I would like to thank both of you. It was really fascinating to interact with both of you. And thank you, a big thank you from the Jindal Law School for joining us for this very fascinating discussion. And I hope that in the future we will have more opportunity and more scope to interact and create more avenues for participants to know more about the relationship between business and human rights and the private actors and human rights law. And on behalf of the Jindal Law School, I would also like to thank all the participants for joining us. Keep participating, and we have more exciting events and panel discussions are coming up in the future, in the next week. So yeah, thank you. A big thank you to both of you.
So thank you very much.
Thank you very much.
Bye.
Bye.